Hello, everyone, and welcome back to the second session of our Sales of Goods Act course. In this session, we are going to understand one of the core aspects of this act, that is, conditions and warranties. Without wasting time, let's begin with our slides. So, today's class, we are going to cover the Module 1, Part 2, that is, Week 2 Conditions and Warranties. Conditions and warranties, what are the definitions and types? Implied conditions and warranties in a sales contract. Let's begin by understanding how the Sales of Good Act defines conditions and warranties. According to Section 12.2, a condition is a stipulation essential to the main purpose of the contract. Breaching a condition gives the aggrieved party the right to repudiate the contract and claim damages. Now let us understand what is the purpose of condition. A condition forms the very essence of the contract. It is fundamental, and without it, the contract cannot fulfill its intended purpose. Example, suppose X wants to buy a car from Y, and the car is supposed to have a mileage of 20 kilometers per liter. Y points to a specific car and says, this car will meet your needs. X decides to buy the car but later discovers that it only has a maximum mileage of 15 kilometers per liter. This constitutes a breach of conditions because the seller's assurance about mileage was a key factor in the contract. Since the mileage was crucial to the contract's purpose, the failure to meet this stipulation is considered a breach of contract. Now that we have understood conditions, let's move ahead. Let's see what are the types of conditions. There are major two types of conditions. One is express condition and implied condition. What does express condition mean? These type of conditions are explicitly stated by the parties in the contract. They can either be oral or written, and both parties are aware of them at the time of contract. Implied conditions. These conditions are not directly mentioned in the contract, but are automatically applied by law or inferred from the conduct or behavior of the parties. They arise due to legal requirements, the nature of the transaction, or customary practices related to the contract. Let's see further and understand the types of conditions with different examples. Conditions as to the title or ownership. The seller must have the right to sell the goods, meaning that they must possess the title or ownership of the goods. If the seller is selling stolen goods, they lack the legal right to do so. In such cases, buyer can cancel the contract, return the good, and recover the paid price. Condition as to the sale by description. When a seller sells goods by providing a description, it is implied that the goods must match the given description. Let's say you're buying a product, it is a car, and the description says that you're getting a particular type of variant and the color of the car is blue. In that case, if you do not get a car at the time of delivery, the car you receive is not matching the description, the variant is different, the color is different. In that situation, the buyer can cancel the contract. Then comes condition as to the sale by sample. When the seller sells good by providing a sample to the buyer, it is implied that a good supplied later must match the provided sample. If the good does not correspond to the sample, it constitutes a breach of condition. So similarly, if someone, let's say a salesperson is coming to your door and saying that I am a manufacturer of a particular cream, okay, and you are running a beauty parlor and you want to buy the cream to sell it in your beauty parlor. The person, the salesperson who is providing you with a small sample is guaranteeing you that this will be the quality maintained throughout the contract whenever we supply the goods. So in the later stage, when the delivery takes place and the goods do not match the quality that was promised in the sample, it constitutes a breach of condition. Then comes condition as to sale by sample as well as description. When both goods are sold by sample and description, they must match both the sample and the description. If they do not match either, the buyer has the right to cancel the contract. Let's go back to the car example. Okay, they expressly mentioned that this is the variant we are offering. So description is there. This is the blue color car. And they also show you a sample model that is present in that particular showroom. And at the delivery of at the time of the delivery, it does not match what they have promised while selling the car to you. That means the buyer has the right to cancel the contract and it is a breach of a condition. Okay. Condition as to quality and fitness or fitness. Generally, if the buyer's responsibility to inspect the goods for suitability. But however, if the buyer informs the seller of a specific purpose for which they need the goods and relies on the seller's skill and judgment, it is implied that the goods will be suitable for that purpose. If the buyer has clearly mentioned or has been vocal about whatever purpose they are buying that item for or that goods for, that explicit mentioning of the purpose says that you have to match the quality and fitness. If the seller fails to meet this requirement and cheats the buyer, it is a breach of an implied condition as to quality and fitness. Because even though there was no description about there was no condition related to description or the sample, but the buyer had clearly said that, mentioned that this is the purpose for which I am buying the goods. So give me the goods according to your expertise because you are the seller. Okay. Let's move forward and understand what are warranties. Now let's understand what are warranties. As I mentioned earlier, a warranty is a secondary stipulation. If breached, the buyer can only claim damages, not reject the goods. For example, let's say you buy a car that comes with a warranty stating that it will be quiet to drive. However, after a while, if you notice that a car makes unusual noise or a sound, while you can't cancel the contract, but you can claim the damages for this type of breach of warranty. Let's understand what is the legal definition. So according to the section 12(3) of the Sales of Good Act 1930, a warranty is stipulation collateral to the main purpose of the contract, the breach of which gives the aggrieved party the right to claim damages but does not allow repudiation of the contract. What is the purpose of warranty? As explained, it is a secondary stipulation. Okay, it would not affect the core of the contract, but yes, it is a guarantee about the quality and performance of the subject matter of the contract. Now that we have discussed the legal definition of warranties, let's move ahead and understand the types of warranties. Types of warranties. There are again two types of specific warranties. One is express warranties, one is implied warranties. Express warranties. These are warranties explicitly stated in the contract by the seller, either in written or oral form. The seller makes a specific promise or representation about the quality, performance, or condition of goods. Example, if a seller guarantees the car that a car has a specific feature like sunroof, it constitutes an express warranty. So in this case, if the sunroof is not provided, definitely the buyer can claim for damages but cannot repudiate the contract. Then comes implied warranties. These are warranties not expressly stated in the contract but are automatically implied by the law to protect the buyer. Implied warranties generally arise due to the nature of transaction or conduct of the parties. Now let's move forward and understand what are the types of implied warranties. Implied warranty of quiet possession. The buyer has the right to enjoy quiet possession of the goods purchased. without inference from the seller or any third party. If the buyer is disturbed by someone claiming superior title over the goods, it is considered a breach of this implied warranty. Implied warranty against encumbrances. The goods sold must be free from any undisclosed charge or encumbrance in favor of the third party. If the goods are subject to a charge, the buyer has to discharge it. They can claim compensation from the seller. Implied warranty as to quality or fitness of a particular purpose. When a buyer relying on the seller's skill or judgment buys goods for a particular purpose, it is implied that the goods will be suitable for that purpose. If the goods fail to serve the intended purpose, the buyer can claim damages for breach of warranty. These warranties ensure that the buyer is protected in situations where certain conditions or assurances regarding the goods have been explicitly mentioned but are reasonably expected as a part of contract. So here, no warranty, such type of warranty will be expressly mentioned in your contract. But these are your rights as a buyer. For example, quiet possession, definitely, if you're buying a good, you that means you are going to be the owner and have the title over that once the contract is success. So after the goods are purchased, nobody can come and interfere. Any third party can come, not only the seller, okay? Any third party can come and interfere with the title or possession of that particular good once the goods are purchased by the buyer. In encumbrances, let's say you buy a property, okay? Or maybe you buy goods. If these goods were already promised to be sold to someone else, to a third party by the seller, and that third party has already provided or purchased or made the transaction for the goods, the new buyer is the innocent buyer and has no idea that the seller has already sold it to any third party. So in this case, the buyer, while buying the goods and making the payments, the new buyer is protected by this implied warranty and can claim for damages. Then comes to quality and fitness of a particular purpose. Again, just like how we have conditions, there is an implied warranty only. But in this case, you can't claim, you only can claim damages and not claim for repudiation of contract. You cannot cancel the contract or repudiate the contract. Now let's see what is the difference between the conditions and warranties in a precise form. So the first feature on which we are going to compare conditions and warranties is nature. Conditions are essential terms of contract, while warranties are secondary or ancillary terms of contract. When it comes to breach in conditions, one is entitles the innocent party to terminate the contract and claim damages. In warranties, it entitles the innocent party to claim damages only. What is the importance? Fundamental to the purpose of the contract. This is the importance of conditions. While warranties are supplementary to the main purpose of the contract. What are the remedies available under conditions? Termination of the contract and damages. While under warranties, one can only claim damages. Let's understand the difference with an example. Conditions, a car engine must function properly is a condition. Warranties, a car's paint color must be specific shade is a warranty. With this difference between conditions and warranty and understanding the concept of conditions and warranty in depth, we come to end of today's class. To sum up, breaching a condition allows for cancellation of contract, while breaching a warranty only entitles the buyer to claim damages. So, in our next session, we will explore further aspects of the Sales of Goods Act. So, stay tuned. Thank you for joining today. And if you have any certain queries, doubts regarding today's topic, please feel free to connect with the LeDroit team or me. Until then, I'll see you next time. Bye bye. Speak legal, speak weightage. Thank you.